Thank you, Catherine, and thank you for having organized this webinar today. Just a very small introduction about me. I'm a 70 years old employment law specialist. I'm the partner in charge of the employment department in Squadra law firm, which is an independent French law firm. We are 40 lawyers. It's a full service law firm. Well, we had this this idea with Catherine to set up this webinar in order to give you a flavor of how to deal with discrimination and harassment. Basically, it's about reacting to such a situation when it arises in the company, of course, but also how to prevent it and to create, as Fiona said, a safe place of work, which is key. And since COVID, we've seen that health status of people, especially in the workplace, have been, let's say it's more complicated, and some people have felt very stressed out by all this situation. And it's important as an employer to be able to create a safe place and train especially managers on how to react to such situation. And we've seen that, well, the topic has quite developed in the past years. So some figures to start with. 1/3 of employees have already been victims of harassment in the workplace, some of them on many occasions. Most of the employees have difficulties to identify a situation of harassment. They feel that they are not well informed about what it is. So when the situation occurs, sometimes it's difficult to identify whether or not we are in a harassment situation. 1/3 of the victims say that their employer was aware of the situation, which means that in some companies, people do not react when a complaint occurs about harassment. It's a survey of well, 2 years ago from Colis Social, which is a specialist of working conditions. So the main points we're gonna see today are a definition of psychological harassment, and we will see that we have a legal definition and also, of course, French case law that defines from case to case, well, what is harassment. We will see also what discrimination is and the current protected criteria of discrimination, sexual harassment and sexist behaviors, and how to prevent discrimination, harassment, how to react. And we will finish with a quiz. You can maybe you can ask you questions after after each topics, or at the end of the presentation, as you like. So what should everyone be treated with equal respect and dignity? Well, mostly this is illegal to discriminate and harass people. It could lead to well, a significant liability for the company and also for the author of such actions, as well for the legal representative of the company. These are criminal offenses. So the employee who is a victim or a supposed victim can also go to well, to the police to file a claim for against the company or the manager, for instance, or even the legal representative. Okay, and of course, a culture of discrimination and harassment damages public image of the company. It will be more difficult to retain the talents and also to hire, recruit people. And sometimes it's very difficult to change the culture, especially in companies where people were very close at the setting up of the company. When you have couples in the workplace, when you have ambient sexual harassment, and we're going to see what this is. And it happens in parties, especially in parties, in companies, and it could lead to very complicated situation. We're going to talk about that, and I will tell you about, well, situations I have seen in files for some of my clients. And it's not my imagination. I'm going to speak about things which sound crazy, but happen in real life. So psychological harassment, well, it's a repeated behavior or comments, and the repetition is key in the definition. The purpose or effect of these comments or behavior is the violation of the rights or dignity of the victim. It could also alter his or her physical or mental health, or compromise the professional perspective, for instance, promotion, through the worsening of the working conditions. This is very important to understand that psychological harassment depends on how the employee is going to react. I mean, some managers, some toxic managers can have a team, a very dedicated team for, I don't know, 20 years. But one day, one of the employees of the team is going to react and say that he feels harassed by this manager. It's not because the manager didn't have any complaint in the past that as an employer, you can say, oh, okay, but this person, what's the problem? He's not being harassed because Tom is a very good sales manager, for instance. It doesn't work like that. And harassment is always, well, seen from the perception of the victim. It doesn't mean that anyone could say that he's being harassed without any motive. You have to, well, there must be an impact on your health, on your working conditions, etc. So as a victim, you cannot just say, I'm harassed because my manager is asking too much. Doesn't work like that. But it's very important to understand that, well, a situation can arise even if you think as an employer that the whole team is okay. You have to dig a little bit more in the facts and the details. So harassment is punishable by 2 years of imprisonment, as we said at the beginning, and the fine as well. These are the, well, the risks at stake from a criminal law standpoint. So it's not in the industrial tribunal that you're going to have this liability. However, in the industrial tribunal, if the employment contract has been terminated, the employee can have damages that are not fixed by the scale, the legal scale. So there is no limit for the damages in case the employee has been harassed. And you can also ask for damages for even if the employment contract is not terminated, because it's a breach, of course, in the normal execution of the employment contract from the employer's side. Well, who can commit harassment in the workplace? It could be between two colleagues, from a supervisor to his subordinates, or the other way around, even if it's more rare. Subcontractors can also be the author or the victim of harassment from employees, vendors, even clients. And as an employer, you are responsible for how people behave in your workplace. And also, well, if you have an employee who is harassing a client, maybe to have more sales, or I don't know, whatever, or maybe someone who is pushing for a date with a client, something like that, and it happens, you will be liable as an employer for such behavior from your employee. Psychological harassment can be collective, can be the result from management methods implemented from a supervisor. And we're gonna talk more about that afterwards. Something that is very important is the repetition in the acts of harassment. You have to, to demonstrate that you have two facts, but one fact can have occurred a very long time ago. Case laws, well, we have case law where an employee has been harassed 20 years ago from one supervisor, and 20 years afterwards from another supervisor. Case law says, okay, it's harassment because the responsible behind that is the employer. So there was a breach in allowing people to work on a safe place. So it could be quite, well, it's quite tricky when we say that to clients. Sometimes they don't understand, but it's not linked to a physical person. It could be several persons, and it's still a repetition of acts. And you do not need to demonstrate intention. So the person who is harassing other people doesn't have to have the intention to hurt them. So it's easier for victims to have the psychological harassment recognized by tribunal because of that. Three focus. The first one is managerial harassment. So it's about the management methods implemented by a supervisor. For instance, constant pressure, reproaches, orders, counter orders, intention of dividing the team. Well, this has been considered as managerial harassment by case law. It's not defined in the labor code, but still it's something that exists and has been recognized by the tribunal for quite a long time. So the supervisor doesn't mean to harass someone in particular, but through the management methods, he's harassing, well, the team. Some people will not complain, but other will. And even if it's not for someone in particular, this is considered as harassment. You also have systemic harassment. It's about the France Télécom case law, if you know that. France Télécom decided to implement a plan, which was called Next Plan, which basically was a social plan, but without economic dismissals. So they pushed people to exit the company, and they have had 25 suicides in 1 year. And so it led to a huge criminal file, which lasts for a very long time, and they were convicted. HR directors, the legal representative, etc. It means that through the whole organization decided by the company, you are harassing people. So it's a system of harassment. And I've seen that in another company. It was not France Telecom, obviously. but there were 3 persons at the top of the company. It was a very big company who set up organization. They changed the culture of the company. They put a lot of pressure all over the workforce. And we had to launch an investigation against them, the 3 of them. And the preventer said, it's a small France Telecom, be careful, people could commit suicide. So it's not something that happens only in other companies. It can really, really happen and quite quickly when you're changing the culture, asking for a lot of results very quickly. And these requirements last for too long and people don't see the end of the project you're implementing. I don't know if you have any question on psychological harassment before moving forward to discrimination.
Yeah. No.
Okay. Okay. So we now have 26 characteristics which are protected by law. They were talking about a new one about hairstyle, but it hasn't been adopted yet, but maybe it will. So it's a list that changes from time to time. So they never remove one characteristic. But they put new ones every now and then. So maybe one day the hairstyle. So you cannot, well, what is discrimination? You cannot take a decision for an employee or behave taking into account this characteristic. For discrimination, you doesn't need a repetition. It's completely different from harassment, at least psychological harassment. So, well, one decision is sufficient, and the sanction are higher for discrimination than harassment in France. I don't know if it's the same abroad, maybe not. But, well, we are really protecting discrimination situations here in France. So discrimination can be direct or indirect. And I think these are principles that are also set up at the European level. So should be the same in other countries. I know it's the same in the UK, for instance. So direct discriminations, well, it's quite simple. I've put some examples. So Andrew is not giving Verity a promotion because she's over 60. It could be your manager doesn't want to attend client's event with a transgender employee. You're not giving a bonus to union delegates, etc., etc. So these are quite simple situations, but sometimes for the victim, it's difficult to say that it's because of a characteristic that the person did not give the right or promotion, etc. But the victim doesn't need to give full evidence of the discrimination. She or he can only say, I didn't got promoted because of my age. And then it's to the employer to explain the decision with objective criteria. So the burden of proof is balanced between the two people. It's the same for harassment. Discrimination can also be indirect. So apparently the situation decision is neutral, but in fact it puts people from a certain category to a disadvantaged situation compared to others. For instance, you have a system of remuneration which would not concern part-time workers, and we know that most of the part-time workers are women. So by your decision of remuneration, you are excluding women, for instance. It could also be men. For instance, you are excluding parents because, well, you also have men working part-time to take care of children. So it will be because of the family situation, which is also a protected characteristic. And what is interesting is that you can mix discrimination and harassment. It's discriminatory harassment. So in this case, you are mixing the two protection for the victim. So it means that discriminatory harassment doesn't need to be a repeated action. So one fact will be sufficient. So what is discriminatory harassment? I'm just giving you an example. And I've seen that, unfortunately. You are in a sales team meeting, and the manager would say to a participant, hey, Steve, I'm really sorry, but your figures were all wrong. I thought that you Asian people were good in math. So why discrimination? The manager is pointing out the origin, supposed to be the origin or the real origin, we don't care, of the person, and also is undermining the work in front of other people, which is a form of harassment. So it will be discriminatory harassment. It seems that you would never have such situation, but talk to the employees in the companies. These are things that still happen in France. So it's very important to educate people because the risks are very high for the company. And you would probably have to dismiss the sales manager for gross misconduct. As I said, the behavior doesn't have to be repeated for a situation to be classified as discriminatory harassment. The employee can be entitled to damages under the two separate offenses. So you double the risks. The employee can also search for the criminal liability of the company for both the offenses as well. Is there any question about discrimination or discriminatory harassment?
There is a new message. Wow, it seems that there are so many more than in the UK law.
I think it's about discriminatory criterion. Yes, we are very protective in France about discrimination. Yes. Yeah, but it's only set up in law. You cannot have another criteria. So it's protective, but it's strictly in the law. Case law will never define another criteria for discrimination. So if it's not discrimination, it could be something else. It could still be a breach in the employment contract, but not discrimination. So let's move to sexual harassment. We have, well, the definition in France has changed about sexual harassment. So we have a repetition for a part of the situations of sexual harassment. It could be so repeated sexual remarks or behaviors that will violate the dignity because of their degrading, humiliating nature, or create an intimidating, hostile, or offensive environment for the employee. So it could also be any form of serious pressure, even if not repeated, exercised for the real of apparent purpose of obtaining an act of sexual nature, whether for oneself or for another person. It's punished, it's the same sanction that for psychological harassment, but it could be increased if there are aggravating circumstances. For instance, a position of power. So in the workplace, it would be that if it's from a supervisor, and if also the author has direct authority over the victim. There is also particular vulnerability, so it could be on a pregnant employee, for instance, or a very young one. So some examples, some are very well obvious, I would say. Of course, you have all the pornographic magazines, things like that. One thing I wanted to point out, because it's maybe less known, is the ambient or environmental sexual harassment. So it's a situation where the victim is not, well, you're a victim of the environment. So people are laughing a lot about vulgar jokes, obscene jokes. They are provocative, the one with the other, but no one is, well, specifically concerned about this behavior. It's just something that happens, I would say, naturally in the workplace. When I say naturally, I don't mean it's normal, but it's the ambience in the workplace. Everybody is talking about that, and but people will be offended and will say, for instance, to the HR manager, I don't feel comfortable because one colleague is always showing pornographic images at lunch, for instance. So we have a lot of case law in France about that, and it's something that happen very often, for instance, in bank, finance, in some very huge group in France. And well, and it was okay. It was okay in the past. Well, most of the time, the person accused from harassment will go on sick leave, even on sick leave, and feel harassed. Yes, and can also file a claim for harassment, for having been attacked for harassment, and say to his employer, "You're not protecting me. I've been attacked. My reputation is very bad in the workplace because it was not anonymous and everybody knows. So I'm on sick leave and I want an exit package." It happens very, very often.
It could happen. That's true, but that's true that what you said. The person who was denied,
Yes,
doesn't understand and doesn't want to understand, and it just carry on as if everything was okay.
But now, employer can do anything. They can do. Then nothing happened. They are obliged to
investigate.
Yes, to investigate.
Yeah, they are not obliged to investigate, and recently High Court has said that it's not an obligation, but it's clearly a recommendation when, after a quick examination of the facts, you feel that there is something wrong, a situation that is unclear, and someone is suffering, and giving you details on behaviors that are, well, could be harassment. It's clearly recommended to make an investigation. The investigation can be launched by the employer on his side without the Works Council. You're not obliged to involve the Works Council in the investigation. You can also appoint an expert or even a lawyer for the investigation. With a lawyer, it would be completely confidential. So all the notes from the lawyer, etc., will not be given to a tribunal. So could be interesting to appoint a lawyer for investigations if it's a very sensitive matter. And you can also, of course, involve the Works Council, and the Works Council can also decide to launch an investigation with the alert, the right of alert it has. In this case, you cannot avoid the investigation at all. It's an obligation when it comes from the Works Council. But every case is different, so it's important to check the facts and reflect on what you want as an employer, what you need to do to protect people. And sometimes a mediation can be more interesting than an investigation. Not for sexual harassment, it's not possible with sexual harassment, but sometimes you have just a conflict, a problem in the relationship, and it's not clearly harassment, it's just the beginning of deterioration of the relationship, and you want to keep both people because they are good elements in your organization. Sometimes mediation can be good to improve communication between the people. Most of the time, the starting point is a lack or a dysfunctional communication. And then it goes to the harassment route. Sometimes it's just like that. So yes, you have to decide on a case-by-case method. So it's a very sensitive topic. Sexual harassment and the role of the victim. We have had reversed case law in this, probably since Me Too. Me Too changed the way we perceive sexual harassment, I think, in France and everywhere. So normally sexual harassment means that the victim does not consent to the conduct. But in the past, case law was blurred because when the employee voluntarily engaged in reciprocal seduction game, it was judged that it was no longer sexual harassment because, it was women. Women were considered as having been provocative or having accepted the situation, and it was not, it was ambiguous, and the poor man could not be, have a proper behavior because he didn't know what the woman agreed to. More recently, it has completely been reversed because even in a situation where the employee and the manager had sexual relationships and were in a couple, the women then said that she had been sexually harassed because the supervisor used his authority to have the relationship with her, and it was judged as sexual harassment. So it's now very complicated because it has completely been reversed, and consent one day doesn't mean consent forever. So it's the principle of this. So it's very complicated because in the workplace we are in real life, and it happens that we have couples in the workplace, and you cannot prohibit this under French law. I know that in some US companies, policies prohibit couples in the workplace, or at least you have the obligation to warn your employer about the situation, and then the employer can decide to move people to avoid problems like that. It doesn't exist in France, but I think we tend to go to this route because we have also had a very recent case law about a nature director who was in a relationship with a trade union member, and a long time ago, and when the employer had this information, he dismissed the guy for gross misconduct, and the French High Court said it was okay. The dismissal was grounded because there was a breach in the loyalty obligation of the HR director, who had in the past negotiated social plans, very significant project for the company, with also with this trade union women. So I think we are more and more going to a transparency society in France. Sexist misconduct, this is different from sexual harassment, but if you have a repetition of sexist misconducts, then it becomes sexual harassment. So this is, well, only defined in the labor code. This is not a criminal offense. So sexist misconduct is, well, any conduct related to a person's sex. Voilà. And it undermines the dignity of the person. So some example, well, I don't know how she got promoted. She must be with the boss. Men never understand anything. So things like that, or sexist behavior. And well, it's quite new that it has been implemented in the labor code. So in the past, it was not a specific problem in France. So it, well, it's no longer the case, and it's very, very complicated because in France we have this culture of making jokes about that, and yeah, it's no longer possible. It's no longer possible, and it's very important to educate people about that, because well, one sexist well joke, let's say, it's not good, but two, it's sexual harassment. So people have to be very careful about that.
But as you say, I think the young generation now knows about that. It's more the older generation who have kids is
yes, but
was anyway educated like that. So you know,
yeah,
that's how they were saying. So yeah, so it's more difficult for them to.
Yes, they think
stop.
it's no longer funny to go to work.
Exactly.
Some could say that. I've already heard that. So I don't know if you have questions about sexual harassment, or maybe I can move forward.
Any question here online? Have you got some questions? I think you can go on.
Okay, so let's talk about preventing this situation. So of course, managers and supervisors have to be very, very aware of this situation, because they are implementing the policies of the company, and they need to lead by example. And they can, well, commonly they can be the author of harassment or even discrimination, because they are the one taking decisions for the team. The employee's actions are the company's actions. So failure to act is the company's failure to act or react. And the manager is expected to know, abide by, and enforce the company's code of conduct, rules of procedure, equal opportunities policy, etc., etc. The manager, it's important to remind the manager that they represent the company in the workplace, but also on business trips, including travel to, from, and downtime, at any business sponsored or business related function, any business related event where she or he is present with colleagues. There is no time out when you go for a drink with your team, when you're a manager. It's exactly the same as being in the workplace, in a meeting room. Sometimes it's complicated for people to understand that. What should you do as an employer if an employee complains? You have to remain objective and neutral. I would recommend not to promise confidentiality. Inform the HR manager immediately if you're not an HR manager. Do not discuss the matter with others. You can assist in the investigation or any other response if required, and ensure no retaliation to the victim. It's very important. The person who is the victim, supposed to be a victim, is protected against dismissal or any other decision. And also the person who has reported or witnessed such conduct. It's a whistleblower protection, basically, and it has been reinforced recently in France. So as long as you're not in bad faith, you are protected against that. It would be very difficult to say that the person reporting this was in bad faith, did it in bad faith. So good luck if you want to go to this route and you terminate the employment contract of a potential victim, because I've never seen bad faith recognized in case law and in practice. So it's more or less the same. If the HR director does not react, case law has considered that he or she must be dismissed for gross misconduct. So it's part of the job to be able to react to such situation as an HR representative. You cannot just close your eyes. So how to prevent, I moved to, maybe the other, it's better like that. So the best practices, you have preventive measures and remedial measures. It's the main point, but you could also be creative about how to deal with that. You have notice boards in France where you have to post information to the employees. You have to talk about harassment and discrimination. You also have to set up ethics charter, code of conduct, prohibiting behavior. Internal regulation needs to also have a specific clauses about that, specific provisions. You need to train people very often, HR managers, but also all the employees, and you can have different training actions depending on the population. Most of my clients do that once a year. It could be online, even online, and you need to have the proof that the person attend the training actions, of course. You can do regular social barometers to check the working conditions, team meetings to talk about this situation. You need to appoint someone who is in charge of harassment in the workplace. It's normally only sexual harassment. It's the legal obligation, but most of the time the person will also be dealing with psychological harassment. It's for companies having more than 50 employees. And of course, promote the dialogue and maybe setting up mediation in the event of conflict. And how to react when you have a complaint. You receive the alert, complaint, inform the victims on their rights and guide them to appropriate people. Sometimes for well, very significant situation, the employer helps the employee to go to the police station because you can have sexual aggression, which is something different from sexual harassment. So it's important to be able to help in a very concrete manner the victim. Take the measures to protect people. You can ask the victim and also the author to completely work from home, for instance, during the investigation, if any. Propose mediation, but not for sexual harassment. You can carry out the investigation, and we talk about that. Take the disciplinary action. Sexual harassment is considered to be a gross misconduct, so you need to dismiss the person. You can't keep someone in your head count who has been accused and who was at the end of an investigation being well considered as having sexually harassed someone. And also take the preventive measures and update your documents on the risk in the workplace. Okay, true or false? An employee's work environment is not sexually hostile if an employee laughs at their supervisor's sexual jokes or does not object to physical contact. True or false? Yes, false. Doug is the VP sales. He loves to joke with his team. Christy is 6 months pregnant, and well, she describes herself as fat or bloated. She and Doug have a very good relationship. She walks into a meeting and Doug refers to her as Moby Dick. Everyone laughs in the room, and Doug knows his comment is acceptable to Christy. True or false? Yeah, it would be, well, sexist behavior or even discrimination. Dave has a mental condition. He occasionally blurts out profanities and nonsensical statements. Some people in the team aren't keen on Dave and often mock him. Dave has not complained, as Dave seems okay with it, and people find it funny. There is no need to do anything about it. True or false? Yes, false. It's well, it's discrimination on health condition. Although generally polite when talking about others of a different race, a manager is often heard making derogatory remarks and racial slurs about people of his own race when needing to criticize their work. This is not racial discrimination. True or false? Well, false. Even if he talks about people of his own race, but it's still discrimination. Jill, age 60, Mark 40, Rob 23, all applied for a supervisor role. You gave the job to Mark because you determined Jill was too old and Rob was too young. This is okay because they were both treated equally. False, yes, sure. You still did made a decision on protected criteria, so it's not okay. Okay. I don't know if you have, well, maybe one last question, if any.
Is there any more questions before we close? And thanks, Morgane, for this very insight webinars on discrimination and harassment.
Thank you, Catherine.